Thank you, Mr. Chair and members of the committee. I am Erin Hennessy. I'm State Senator for District 1, the most beautiful Senate district in the state. SB 380, relative to solid waste rules and landfill containment test, and Amendment 2022-0692S is what I'm here to speak to you about today. The amendment replaces Section 3 of the original bill. As amended, the bill does four things. It creates a legislative committee to study prohibiting any landfill in the state from accepting waste from a municipality that does not have a solid waste management plan. This committee heard a lot of testimony last year around solid waste and our state's current capacity. Solid waste management plans can help reduce solid waste and prolong the life of our current landfills and any future landfills that we see. Because there are many open questions regarding costs to our municipalities and to the state regarding these plans, the committee will study this. The second part of the bill sets up another committee to study the creation of a solid waste disposal site evaluation committee. Again, you heard hours of testimony last year on potential issues with siting of new landfills in the state. This committee looks at creating a site evaluation committee to evaluate proposed sites in the future. The third part, via Amendment 0692S, adds additional analysis requirements to the alternative site analysis requirement for permit applications. And finally, Section 4 adds the word net to the public benefit requirement under New Hampshire Solid Waste Management Statutes 149M. One of the biggest issues that comes up over and over again in solid waste public hearings is that we only require landfills to provide a public benefit, which is a very low bar, instead of a positive net public benefit. This section adds parameters around the definition. Thank you, Mr. Chair, and thank you, committee. I apologize, I have to run to an executive session.
That's fine, we understand totally, and thank you for your testimony. I'll recognize Senator Ricciardi, who has similar time constraints, so we appreciate you being here.
Okay. Thank you, Mr. Chairman and honorable members of the committee. I'm Denise Ricciardi, and I'm the state senator for the beautiful District Number 9. As a supporter of HB 177 from 2021, I appreciate the time and effort your committee has put into learning about solid waste issues in our state and for considering this legislation before you that makes slight but much needed changes to our solid waste management statutes. By requiring a net public benefit for new landfills, looking at developing a site evaluation committee, and solid waste management plans. This bill helps to set New Hampshire up for a more reasonable approach to the future of New Hampshire's solid waste management needs. I thank you for considering SB 380. Thank you, Mr. Chairman and members of the committee, and I'm running to exec bills.
Thank you for your testimony, and we know you have to run. Thank you very much, Senator. Recognize Brian Gould.
Thank you, Mr. Chairman, members of the committee. My name is Brian Gould. I'm a lawyer in Concord at Cleveland, Mars and Bass. It is our privilege to, one of our clients is Casella Waste Systems, and it's our privilege to represent the company. In the time I have this morning, I'd like to address three topics: some internal inconsistencies in the bill, a proposed definition of net public benefit that does not determine actual public benefit, and what I assume would be the unintended consequences of this bill. Internal inconsistencies. The first is that under Section 2, paragraph 4A of the bill, it says that the legislative committee to study the solid waste disposal site evaluation committee concept is to determine a definition of net public benefit and what factors should go into that calculation. So that's within the charge of the study committee. But then Section 4 goes on to amend current RSA 149M11 paragraph 3 to redefine public benefit before the study committee actually makes its determination. The second internal inconsistency is found in...
Excuse me, could you point to where that Section 4 is in the bill? Is it page 3
Sure.
or where are we at?
That's on page...
Page 5. Page 4?
I thought it was 4. Maybe that's right. I just saw it and circled it. I have page 2 where it says net public benefit, but I think it's fine.
That's the first thing he
The first
cited,
one,
but
yeah.
where's the later?
Section 4, it begins at the bottom of page 2, Senator.
That's where, yeah.
But the redefinition of net public benefit, or the additional definition, is near the bottom of page
Okay,
3.
got it. Thank you.
Sorry.
That's okay. It's all right. The second internal inconsistency is the statutory definition of public benefit. The current statutory definition applies to all proposed solid waste facilities. Now, under RSA 149M to paragraph 9, facility is defined to mean a location, system, or physical structure for the collection, separation, storage, transfer, processing, treatment, or disposal of solid waste. RSA 149M11, the public benefits statute, applies to all such facilities. So transfer stations, MRFs, incinerators, landfills, you have to show a public benefit for all of them. But the new paragraph, subparagraph 3E, applies only to landfills. So you've got this list of criteria to determine public benefit in RSA 149M11 that applies to all facilities. And then in the midst of that, in paragraph E, it starts the incremental harms that a landfill would likely cause. So we have a set of criteria that apply to all facilities, and there's nothing in this section that explains why landfills are to be treated any differently from any other facility. There's also an under-inclusive definition of net public benefit. If you think of the term net public benefit, it suggests a weighing of all of the advantages and disadvantages of a proposed facility. If this were actually the objective of the bill, then it could not ignore the importance of statewide availability of reasonably priced disposal capacity, environmental harms that actually arise from overly expensive disposal, the effect of price competition, and the regional, national, and international market. The bill actually just throws up obstacles to a finding of public benefit. Under section 3D of section 4, which is an amendment to paragraph 3 of 149M11, it says the ability of the proposed facility to reduce transportation costs and tip fees so that waste generators within New Hampshire can reduce costs relative to the status quo. Now, is it only a public benefit to the state of New Hampshire if the facility will actually reduce transportation or tipping fees? What if it stabilizes tipping fees? What if it mitigates increases? Those would be benefits certainly to the citizens of New Hampshire, but that would get ignored in this formulation of public benefit. Under section 3E, which is the next section, the bill assumes that there will likely be incremental harms from landfills and includes a laundry list of such potential harms. Such impacts may include noise, odor, traffic, groundwater pollution, etc. Now, loading up the statute with potential harms while ignoring potential benefits does not result in net public benefit. It's a thumb on the scale of DES's determination. Proposed subparagraph E also implicitly discredits the effectiveness of DES's regulation of waste facilities. The entire purpose of the hundreds of rules that DES has promulgated governing waste facilities is to prevent groundwater pollution, surface water pollution, and greenhouse gas and other emissions. Yet, this bill would require DES to consider impacts from exactly those sources. Is DES under this bill supposed to assume, contrary to 40 years of experience under this set of regulations, that the environmental protections accomplished by its rules are ineffective? Is it supposed to assume that all leachate will be released from the landfill, that there will be no capture of landfill gas, and so forth and so on? I don't know how DES accomplishes what it's asked to accomplish in this section. And finally, the unintended consequences, I think, to municipalities. The fiscal note describes the potential impacts on some municipalities in the state. DES says that it will be unlikely to increase its costs. I don't know how that can be the case under this bill, because there are a number of impacts that DES does not have the expertise to consider. DES is not an expert in traffic and other aspects of development of such a facility. Municipal landfills, those that are owned by municipalities, are exempt under RSA 149M 11(7) from one requirement of the public benefit showing, but that exemption would not extend to proposed paragraphs 3D and E. This means that the Lebanon, Nashua, excuse me, and Mount Washington Valley landfill in Conway would be subject to D and E, which would increase their costs substantially and could very well prevent any expansions of those facilities. So this bill is not based on science or good public policy. It is an attempt to kill a particular project. That, in my view, is not the purpose of the legislature, and I respectfully submit that the committee ought to vote this bill inexpedient to legislate. Thank you.
Thank you, Brian. Questions from the committee? Seeing none. Thank you very much.
Thank you.
Appreciate it. Henry? Yeah, we can.
Do we have a copy of the previous testimony?
The one we just spoke?
Yeah.
I didn't bring an extra copy. I can certainly prepare one.
Thank you. That'd be a big help. Thank you.
A huge help. Yeah, thanks.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Henry Bayou, and I'm here on behalf of Resource Waste Services. Resource Waste Services is kind of a unknown gem in the state. They process construction and demolition debris and recycle a lot of material. The woods go to a market. They take the metals and sell those. And what can't be recycled ends up at the landfill, but they do prevent a lot of materials, construction, demolition debris, from being landfilled. And they are here in opposition to this bill. Resource Waste Services has facilities in Salem and in Epping. And they're the largest recycler of C&D material. A couple of things to say about the bill, and Mr. Gould brought up one of the points I wanted to bring up, which is that the substantial change that is going to be made to the public benefit in this bill is also, in the other section, directed that a study committee take a look at it and come up with something. So it just seems inconsistent that you would put a major change in state statute before you have the study committee take a look at it. And speaking about the study committees, so there's already a solid waste working group, which Senator Gray serves on. I believe Senator Waters, I think you're on it too. No, you could be on it though. So there are two study committees that are being proposed in this bill. There is a bill that is going to pass the House probably today or tomorrow. It's on consent calendar that sets up another solid waste study committee. At the end of this session, we could have 4 study committee working groups, of which all of us in the room here are probably going to be in those same meetings, because you're going to need the DES experts, you're going to need the people in the private sector, you're going to need Senator Gray. He's going to be on 4 committees over the course of this summer looking at this stuff. I mean, we need to take a deep breath, calm down, either direct the solid waste working group, which Senator Gray serves on, to take a look at some of the issues in here, or consolidate, because there's just not enough hours in the day, days in the week to spend the amount of time having people work on these issues. So I think prioritization is good. I mean, we're all sitting here today because this bill is attempting to try to stop a landfill up north, and not getting into the merits of that, whether that's good or bad. The question I have is that a reason to have this legislature make some dramatic changes, which are going to affect all these other facilities? And I think it's not worthwhile, that we all need to take a deep breath and take a measured approach to looking at the policy, and that's it.
Thank you, Henry. Questions from Mr. Bayou? Seeing none, thank you for your testimony. Tom Tower. Welcome.
Morning.
You have the floor.
Thank you. Mr. Chairman and the members of the Senate Energy and Natural Resources Committee, for the record, my name is Tom Tower. I appreciate the opportunity to testify today. I'm a resident of Whitefield, New Hampshire, and I'm here speaking in support of Senate Bill 380. I would also like to thank the prime sponsor, Senator Hennessy, and the 8 additional bipartisan members of the Senate, along with the 5 members of the House who have co-sponsored this bill. Senate Bill 380 is a very important piece of legislation, and I support all aspects of the bill, but in the interest of the committee's time, I would like to talk specifically about the importance of considering the net public benefit when reviewing an application for a solid waste permit. Every development project has its pros and cons. It is the nature of development. When the state and communities go through a permitting process, it is an opportunity to take a holistic view of any given project and determine if it will bring more pros than cons, more good than bad. This net public benefit is crucial in good permitting and is unfortunately currently missing from the state's solid waste permitting process. For decades, the New Hampshire Department of Environmental Services has been instructed only to consider gross public benefit, in essence, considering the potential pros of a project, but not how they may balance against any potential cons. Senate Bill 380 would allow DES to consider the other side of the ledger, using any reasonable analytic methods. Senate Bill 380 instructs DES to consider one specific kind of benefit previously ignored, which is the ability of the proposed facility to reduce transportation costs and resultant carbon dioxide increases, along with several kinds of harms that might equal or dwarf all benefits, such as noise, environmental pollution, reduced property values, and traffic accidents. DES does not have to compare costs and benefits quantitatively, but merely make an evidence-based finding that there is positive net public benefit. The economics and science of estimating net public benefit is completely routine and already developed. In fact, as you may recall, President Reagan, 41 years ago, with Presidential Order 12291, required all federal agencies to estimate the benefits and costs of their regulations and make sure that benefits exceeded costs in each case. The impacts of a solid waste site will be present in a community for multiple decades. Let's make sure we consider all the pros and cons of a potential project and know that it will create a net public benefit before we permit. This section will help DES, will modernize our statutes, and is just plain common sense. I'd like to thank the committee again for the opportunity and happy to take any questions you may have.
Thank you for your testimony. Questions from the committee? Seeing none. Thank you very much.
Thank you.
John? Tolton? Going once. John? You want to see if there's a John out there? John Tolton? Tutland?
He's outside.
Oh, okay. Well, we'll wait for him. While we're waiting for him, Wayne Morrison.
Can't avoid me.
Welcome. Oh, you'll be next, John. You have the floor.
Good morning. Chairman Avard, members of the committee, thank you for the opportunity to provide testimony today. For the record, my name is Wayne Morrison. I am a resident of Mount Vernon and also a property owner on Forest Lake in Whitefield. I speak to you today in support of Senate Bill 380. I believe Senate Bill 380 is a smart, common sense bill that acknowledges the need for solid waste reform to better serve and protect the health, safety, environmental interests, and solid waste disposal needs of citizens and businesses throughout the state. Although I support all elements of the bill, in the interest of time and to avoid redundancy, I will focus my testimony specifically on the portion of the bill calling for the creation of a committee to study the development of a solid waste disposal site evaluation committee. Siting a landfill is a complex, lengthy, costly, and impactful process for applicants, for DES, and for the regional stakeholders who are impacted by the decision for decades to come. The siting process is often controversial. It's poorly understood. It's often communicated publicly months or even years into the process, and is often subject to a great deal of resistance and, in some cases, legal action. Currently, the siting of a landfill is a reactive process triggered by a permit application. Forming a committee to study the development of a solid waste evaluation committee would provide an opportunity to rethink this process. The Site Evaluation Committee could proactively assess and catalog suitable landfill parcels in the state and assist DES and applicants by pre-screening those sites. The committee could also ensure potential sites are optimized and aligned with the state's solid waste plan, waste reduction goals, capacity needs, and sited to minimize transportation and infrastructure costs by better aligning disposal site locations with where waste is generated and leachate processed. Rather than treating a landfill siting decision as a tactical or transactional event triggered by an application, a site evaluation committee could elevate the process to a more strategic level, better aligning the decisions with the state's solid waste needs and more optimally leveraging their capacity. Additionally, a site evaluation committee could improve the transparency of the process by providing a vehicle for applicants and stakeholders to review site plans, raise concerns, and render a decision at the front end of the process before significant investments are incurred by applicants, by DES, and by stakeholders. Landfills sit at the bottom of the solid waste hierarchy for good reason. They come with great risk and unwanted side effects that impact the health, safety, environmental interests of our citizens, our businesses, and our tourists. If and when additional solid waste disposal capacity becomes necessary, improving the siting process now is an important step to ensure that such decisions are made in the context of the state's solid waste plan and, in fact, in the state's best interests. Chairman Avard, I urge you to support Senate Bill 380 and help initiate the formation of a committee to investigate opportunities to drive much-needed change and improvements in the solid waste disposal siting process. Thank you for your time. I'd be happy to answer any questions.
All right. Thank you for your testimony. And questions from the committee? Not all at once now. All right.
Thank you.
Thank you. All right. So, John. Welcome back, John. You have the floor.
Thank you, Mr. Chairman. Members of the committee, my name is John Tuthill. I'm from Ackworth, New Hampshire in Sullivan County. Former member of the House Environment and Agriculture Committee back 20 years ago or so when we were dealing with some of these same issues. As all of you know, I'm sure Sullivan County has a long history with the waste management industry. And it's one reason that I'm so interested this year in seeing the state really grapple with policy issues, planning issues particularly, and sort of catch up. We've let a couple of decades go by while the industry has evolved and consolidated. There's been some positive developments, but also I think municipalities at the local level are less and less able to sort of interact directly with the industry, and this is, I believe, where the state of New Hampshire has a role to assist with planning. I strongly support SB 380 as a vehicle and the concepts that are presented in its points. I think it probably is going to require further attention and work as we go forward. But I see this as an essential piece of what is going on between the House and the Senate this year, given the situation, particularly in the North Country, but frankly statewide and region-wide. This issue is being discussed in Augusta and Montpelier, New York State, Boston, a little ahead of us, which is one reason I think we're feeling the kind of pressure we are with importation, both of construction and demolition debris and municipal solid waste. I would just like to emphasize, particularly picking up on a point from the representative for Resource Waste Services, I believe it was, in Epping and Salem, about consolidation of the study committees. I think that that's a valid point. I would look at what each of these committees is doing and then consider what the working group is doing under last year's House Bill 413, looking at their mandate. But we obviously are going to need some time here. We really need to, I think, look at a pause, perhaps something like a moratorium on permitting, which is what happened with C&D several years ago, while the state sort of catches up after a long lapse in effective planning. It's occurred to me that the Office of Strategic Initiatives might be able to assist with some of this, replacing the Office of State Planning from some years ago. DES also has resources to do planning, potentially, but they need support in that. They need to fill vacancies and they need funding. I mean, I will leave it there. I know you have a lot of business to deal with today, but I strongly urge you to take this bill seriously and to move it forward and to come up with a piece of legislation that will support local municipalities and also protect the state's interest just in terms of community development, environmental resources, and public health. Thank you very much.
Thank you for your testimony. Questions from the committee? Seeing none, thank you very much.
Thank you.
Appreciate you being here and for your past service. Elliot?
Good morning.
Good morning.
Thank you, Chairman Everett and the committee for providing this opportunity for me to testify in support of 380 and specifically in support of the amendment addressing the alternative analyses requirement for landfill permits. And thank you to Senator Hennessy for her sponsorship of this bill. We believe the amendment on alternatives analysis is a critical part of the bill. A landfill permit applicant is already required under DES rules, specifically ENVWT 524.02, to conduct an off-site alternatives analysis for any project that will result in more than 1 acre of permanent wetland impacts. The problem is, and it's a very big problem, DES rules are totally silent on what an alternatives analysis should look like. As a result, an applicant has no guidance on how to conduct an alternatives analysis. Furthermore, DES decision makers have no established criteria to evaluate such analyses. DES readily acknowledges that this gap in its rules has existed for a couple of years and that it is problematic. And DES acknowledges its single sentence rule on alternative analysis was originally conceived for small industrial projects, not for large projects such as landfills. In addition, the lack of guidance in statute creates problems. The biggest problem is the potential for DES to review applications and to reach decisions that are inconsistent with legislative priorities, priorities that are needed to guide a regulatory agency such as DES to fulfill the will of our state residents. At present, the requirement is analogous to a black box exercise. A landfill applicant gets no guidance in DES rules, for example, on a number of factors. For example, how many alternatives it must consider, in what locations, what environmental characteristics it must evaluate, what quality of life considerations it must address, and actually the list goes on. What SB 380 as amended will do is provide some minimal guidance from the legislature as to what the legislature expects from DES in evaluating future landfill permit applications. Specifically, the amendment makes clear that a landfill applicant must demonstrate a few things, mostly that it has not chosen a location solely on the basis of what's good for the applicant, but rather must make a minimum showing that the location it has selected will not result in undue environmental damage or undue harms to quality of life. Given the prospect of the GSL project in Dalton, permit applications being filed fairly soon, probably this year, at DES, absent guidance from the legislature, DES will have to determine essentially on the fly what an alternative analysis should look like. We think a far better solution is for the legislature to pass SB 380 as amended. Again, thank you for this opportunity. I'm happy to address any questions you have. And in addition, I want to make the point that supporters of SB 380 are happy to work with both the committee and DES in possible language revisions to make the amendment better, recognizing that it's probably new to you, perhaps as quickly as this morning. And I do have hard copies that I can distribute.
Thank you. Questions from the committee?
4 or 5?
Okay. Yeah, yeah. Oh, yeah, I'm gonna let him all of that. I know. Yeah. Oh, I'm definitely, yeah. He's not getting out of the room without it. Yeah. Denise, Matt Leahy? From the Forest Society in support.
Good morning. Thank you,
Good
Mr.
morning.
Chairman. I'm passing out written testimony. I won't repeat that, although I'd be happy to answer any questions you may have. So just to be brief, though, I'm Matt Leahy. I'm the Public Policy Director for the Forest Society. We support this legislation. And it's, the reason I think is basic for us. The current state law does hold that landfills are the least preferred method to deal with our solid waste issues. And, we view this bill as a way to start moving state policy away from the creation of new or more landfills and hopefully towards looking at other methods to deal with all this waste and trash that, that we create. So we support the bill And thank you very much for your consideration.
Thank you. Questions from the committee? Well done.
Thank you, Mr. Chair.
All right. All right, BA is not in support, does not want to speak, but let's see, Adam Sandel, welcome.
I have written testimony also. Should I hand that out now? Or?
You can do both, yeah. And for the record, you folks are opposed. Do you represent any particular industry or?
I'm here with CMA Engineers today.
CMA Engineers?
CMA Engineers, yeah. Thank you all. I'm Adam Sandal. I'm with CMA Engineers. I'm a vice president and a professional engineer, licensed in New Hampshire, and I'm here in opposition to Senate Bill 380 today. And thank you guys for taking my testimony here. So I just want to speak a little bit about the changes to the public benefit demonstration. So we have prepared many public benefit demonstrations, and it's a I'm sure you all know it's a component of a very large permitting document to for permitting either solid waste facilities. Most of the time that would be a landfill, but sometimes that could be a transfer station. Sometimes it could be a material recovery facility. And if you go through the RSA, it's very specific about what you need to show for public benefit. Does this facility provide needed capacity to dispose of New Hampshire's waste over a planning period term of 20 years? So it's an important component of a solid waste application, but it's 100 pages of a 2,000 page document, and a lot of the changes and things that we're looking to have the public benefit include is provided in great detail in this solid waste application. Some of the examples that were described in here are noise, odor, traffic, groundwater pollution, surface water pollution, greenhouse gas. The solid waste regulations lay out what the requirements are for including engineering controls to be able to monitor and control these items on the list. And the public benefit demonstration is, like I said, it's very specific about what it needs. And these other things, while they're important, you make the public benefit demonstration not as concise of a document. And some of the other, just a couple of the other items here that I wanted to touch on was for the incremental harms on property values, tourism, outdoor recreation, and wildlife. I think that that's going to be really difficult for DES to be able to quantify what those impacts are. What are the thresholds for affecting property values and tourism and outdoor recreation? By adding it to this RSA, they're going to be required to make that determination, and I don't know that that's something that DES has ever done or is capable of doing. So that summarizes my written testimony. I'd be happy to take any questions that you have.
Thank you for taking the time. Senator Waters with a question.
Yeah, thank you, Mr. Chairman, and thank you, Mr. Sandal. I don't know if you've seen the amendment, and if not, Dale, do you have one you could let him look at? So this, you may have heard mentioned, has to deal with the alternative site analysis.
Yeah, no, I did. I saw this late last night.
So my question to you would be that since you prepare these kind of public benefit statements, and I would imagine this then would need to be included in, if somebody were to hire you to do the job under this bill, this would probably be included in the work you'd have to do?
Yeah, so I guess the public benefit demonstration is required when you are expanding, like if you have a landfill and you're expanding the landfill, you need to show that that capacity is needed. The landfill's already there, and 90% of the applications the site is already there. So this would apply to facilities that are not there, that are new facilities, because you wouldn't if you're expanding a landfill and you're providing capacity, your alternative wouldn't be to put a landfill in a new site. So when in New Hampshire, you can't build something very large without impacting some wetlands in some way. It's just the landscape of New Hampshire. So the alternative site analysis is part of the wetland rules. So if you're applying for a major wetland application, you're required under the rules to do this exact analysis.
So I guess, if I may follow up, Mr. Chairman. So I guess my question though is that wouldn't this, in a sense, require you to see throughout the state whether there is any alternative site that you then would have to examine? I mean, another 500 acres somewhere, someplace, or not?
You're talking under the wetland rules, or are you talking
under this amendment? This isn't just about wetland rules. It's about, if you're going to propose a site, you will have to have demonstrated that you have to have identified alternative sites.
for a brand new site?
Yeah.
I mean, that's been done. It is being done, and solid waste can,
Yeah.
So what you're saying is that if there's a site that has no wetland impacts, there's some site, 1,000-acre site in New Hampshire with no wetland impacts, that this would be a catch-all to whether or not the site is a good site. I mean, if there's no wetlands on a site, would tell me that's a pretty good site.
I guess I was just trying to ask you as a professional in this field how you would read this, and I appreciate that. So thank you.
Yeah. I think that it makes sense to evaluate what the best site is for your facility. Sure.
Thank you.
Thank you. Any further questions? So basically, you go through this whole process and to find out where the best location is.
It's part of. It is certainly part of the evaluation. You want to make sure that if you're looking for a location to put a solid waste facility, there's a lot of factors that go into that selection process. It's access, it's wetlands, it's what's surrounding you. It's a very comprehensive process.
All right. And if the spirit of this bill goes through, you would almost have to duplicate that someplace else to find another location. So driving up the cost just for the application, I would imagine, right? Because you'd have to find another place to be as suitable as I would assume.
Are you talking about a new site? You're not talking about a site that's already existing.
Right. I'm assuming.
Yeah.
This seems just as complicated in my.
Yeah, I mean it's already done. It's already wrapped into other regulations. It's part of the permitting. It's part of the permitting documents. It's already there. It's just duplicate.
You said it easier than I did. You should be up here. Further questions from the committee? Seeing that, thank you very much for your testimony.
Thank you.
Garrett? Welcome. And you're with Waste Management?
Waste Management, correct. That will not get
And your last name is
Trierweiler.
Exactly. Well done.
All right, thank you.
You have
Won't
the
get too far without my glasses, unfortunately. Good morning, good morning, Chairman Avard, members of the committee. My name is Garrett Trierweiler. I'm the Director of Public Affairs for Waste Management. Waste Management is the leading provider of waste management services in North America. And in New Hampshire, through our turnkey recycling environmental enterprise, which is commonly referred to as TREE, landfill facility, through 4 solid waste transfer stations, a recycling facility, and upwards of 200 waste collection vehicles. Waste Management manages roughly 40% of the waste and recycling generated in the state of New Hampshire. We feel this gives us a valuable perspective on the practical realities of managing solid waste and complying with the laws and regulatory requirements in the state. We very much support the work being done, as mentioned several times before, by the legislature concerning solid waste and recycling practices, ways to increase diversion and to lessen the dependence on disposal. The Recycling and Solid Waste Management Study Group and the Solid Waste Working Group formed by the legislature will certainly help guide the planning for solid waste management in the future of New Hampshire. We are actively participating in this planning effort. I just want to notice that Steve Podgy, our Director of Disposal Services, is on that committee and is very active. And we think it's important that the legislature allow this group to do its work before making the significant changes that would, that Senate 380 would, including the fact that some of the same requirements that are considered here are also under the purview of that working group. So specific to Senate 380, we do not believe it's either practical or necessary to require all 234 New Hampshire municipalities to develop a plan and to in the meantime, prohibit the disposal of their solid waste until each of them incur the significant time and expense to prepare individual waste plans for review and approval by the state. As you all know, most cities and towns go out periodically to contract for collection and for the disposal services, and the location where their solid waste is disposed of changes over time. This bill could result in a requirement that municipalities develop or revise plans immediately and submit them to the state for review. The bill does not address the effect this process will have on numerous existing contracts that assure the timely flow of the solid waste continuously generated within the state to permitted disposal sites. Reviewing and approving these plans initially and then subsequent revisions will also require additional agency staffing resources and funding. These requirements will add further burdens on an agency that is already challenged by the demands that they're placed on it right now. This concept appears similar to what was required years ago when municipalities were asked to join solid waste districts and develop their plans addressing similar matters. These districts were often found to be ineffective, were administratively cumbersome, expensive, required frequent modifications, generated unfortunate disagreements, and as a result, many of them have been dissolved. We also don't believe that there is a need for an additional citing procedures and criteria which go beyond the existing comprehensive public health benefit requirements that must be met prior to permitting a facility. The criteria in evaluating in solid waste facilities, as spelled out in the solid waste rules, are comprehensive and fully protective of public health and the environment. The current rules require projects be subject to public review, comment, and hearings, and include a comprehensive technical evaluation by the DES. The current public benefit requirement is sufficiently comprehensive and carefully considered and applied to each application in the review process prior to issuing a permit. Additionally, these facilities must be reviewed and approved at the local level to ensure they comply with local zoning and planning board requirements, which both include public reviews and hearings. Establishing a solid waste disposal site evaluation siting board to evaluate solid waste facilities will bring with it additional costs, time delays, and regulatory burdens to an already complex and very challenging process, one that we have been through several times. The bill would ask the proposed solid waste disposal siting committee would task them with evaluating environmental and operational conditions to determine whether a site is appropriate, while also assessing any incremental effects from a landfill. These requirements are already addressed in the solid waste rules and federal permitting requirements, and requiring another review from a yet-to-be-determined board would add further complexity to this very difficult process. For one example, the bill proposes adding the potential impact of emissions associated from transportation of material to and from a proposed facility. To our knowledge, this is a requirement that has not been imposed on any other business in the state. If such a requirement were to be arbitrarily imposed on other industries such as tourism, for example, it is likely that a negative result would be obtained from that analysis. Further, a net public benefit is proposed to be assessed on behalf of a host community and or abutting municipalities by an independent third party. This leaves open a question as to how the qualifications of this third party are determined, how they would be selected, and in what sense are they considered to be independent. A host community could be supportive of the facility, but an abutting municipality may not be if they are not receiving direct benefits from the operation of the site. This law would expand the likelihood that an operator would need to enter into host community agreements with all abutting communities, each with an associated host fee. This would increase costs considerably, and those costs would then be passed on to the municipalities and the businesses who use that facility. Lastly, a provision of the bill that we support is that an application should be reviewed under the regulations and statutes in effect after the completeness determination is issued by the DES. I want to thank you very much for the opportunity to provide these comments, and I would be happy to answer any questions.
Senator Waters.
Thank you. Maybe not a question you're expecting, but in the reference to the vehicles issue and the vehicle emissions and noise, you know, we've had some conversations about that on Route 16 access for the facility in Rochester. Did your company looking into moving towards hydrogen and electric vehicles for haulage?
So, yes. So currently, our new hauling district in Rochester is transitioning to natural gas. So the first step is to get off diesel. And so we do have natural gas at that site. I was just on a presentation recently with our fleet director nationally, talking about getting involved in electric. We're actually going to be piloting an electric vehicle, a collection vehicle in Londonderry. It's going to be one of the few in the whole country, and Londonderry, New Hampshire is going to be one of the beneficiaries of that pilot. So yes, I will say it's a ways off when we talk to some of the technicalities of the battery and how that all works. But the short answer is yes, we are.
Thank you.
I think Nashville uses natural gas, don't they?
I'm not sure, but is that, cause I don't know. I just know that our Rochester facility, that is the new facility, is moving all those trucks to natural gas. We have a fueling station.
Thank you.
Further questions? Seeing none. Really
Thank you
appreciate
very much. And I dropped off my written testimony as well.
Thank
to the staff.
you.
Okay, thank you.
So I have nobody else here to speak. However, I would like Mr. Wimsatt to join this conversation if you have any input. It would be great, a big help.
Good morning, Mr. Chair, members of the committee. For the record, my name is Mike Wimsatt. I serve as Director of the Waste Management Division for New Hampshire DES. The department is not taking a position on this bill, and we don't have a letter of testimony, but I did attend the hearing here this morning, anticipating that there may be questions that you'd want to ask of DES. So I'm happy to entertain any questions that you might have.
Senator Waters.
Good morning, Mike.
Morning.
Nice to see you. So I had a few. On the net issue, which I'm sure you've been hearing the conversation, and there's really seems to me there's two issues. The first, the committee is supposed to look into it, and then secondly, it makes some changes in statute. And I didn't know if you had any thoughts about where you thought that process, how that process ought to be undertaken.
Sure. Yeah, thanks for the question. And again, we don't take a position on the bill, and that includes this particular provision of the bill. However, in reviewing it, we do have some concerns that it appears that sort of within the bill itself, the cart kind of goes before the horse. So there's a committee to study, what site evaluation, something like a site evaluation criteria committee, and also what net benefit might actually look like. But then there's a provision that puts net benefit into the statute and makes it, if the bill were to pass, would make it effective, upon passage. So we have some concerns about that. I think others have expressed some concerns about DES's ability to evaluate certain aspects of the net public benefit, and we share those concerns. We don't have the kind of expertise and the kind of experts or professionals who are necessarily equipped to evaluate some of these particular benefit or impacts that are really in some sense separate and apart from looking specifically at management of waste at a given site. So if that were to pass, I think we would probably need to look at that really carefully. We need more guidance from the legislature on what that really means and how we would make a determination. And we would probably need to have the ability to bring in or either hire contractors or experts who would help us with those various provisions.
Oh,
Yeah, and then, I don't know if you have the bill in front of you, Mike, but on page 3 down at the bottom where it does make that statutory change and provide the list of what the net benefit should include, these incremental harms list here. Well, I mean, there's two things, reduced transportation and tipping fees, and then also the net incremental harms are now supposed to be included. So as you look at both those issues, do you have some thoughts about how DES would respond to making determinations on what's listed there in both C, D, and E?
To be honest, I think it's something we would have to really spend some time with. And as I said, I think the transportation one in particular, we have no experts on transportation at DES with respect to, I mean, we do have people in our air division who have looked at, specific issues related to air quality in transportation. But beyond that, we really don't have any staff that are equipped to evaluate that.
oh,
Yeah, thank you. And then, I don't know if this is speculation, I'm just trying to read the bill. That we've had a lot of discussion, and there's conversations ongoing about the issue about half the waste coming from out of state, half coming in. I tried to take a shot at that to get around the Interstate Commerce Clause with the tipping fee and so on and so forth. Mm-hmm. Is there anything in this bill, because of the net public benefit, which means New Hampshire folks, and the transportation issue, that this bill in any way would be a way of, or have the effect of reducing what out-of-state waste comes in, or would it really have nothing to do with that?
Well, and again, I'm speculating here because I don't know how this would be implemented. But if we were to implement this as it's written, I suppose you could have a scenario where the agency would evaluate, increased truck traffic and increased transportation into the state of out-of-state waste.
No.
And to the extent that our charge was to determine whether there was a net public benefit to the people of the state, we might conclude that additional truck traffic didn't have any net public benefit for them. So it could impact that. And how that would intersect with interstate commerce issues, I'm not qualified to say.
So if I just follow up, and I would say, though, that would you potentially be able, in your review of an application, to look at the percentage that the company was willing to say would be dedicated to in-state waste? Or would they not really be able to do that under the ICC?
Well, it's not uncommon for an applicant to provide information and estimates about what portion of the waste that they accept would be in-state waste versus out-of-state waste, and you can kind of infer that even if it's not provided, in the sense that the net public benefit the public benefit analysis that's currently conducted requires them to estimate, and we try to verify those numbers, what the need for in-state waste capacity will be and what portion of that need would be served by a proposed facility. So by difference or by subtraction, you can figure out, and they also request a particular capacity over a period of years for that facility. So just with the simple math, you could make an estimate of how much waste might actually come from out of state.
If I may, I just got two more, I think. So it seems, we have now on the net benefit, we've got the committee that might look at it. We've got a kind of, not exactly preemptive, but a direction within statute to say, here's what you got to do right now. I suppose a third alternative would be to pass a bill that tells you to initiate rulemaking on net public benefit and then give you some guidance as to what we mean about that. Now, would that, I mean, in a sense, isn't that where we're going to end up anyways by the committee route?
I don't know the answer to that, Senator. I mean, if one of the concerns we have, we've got a committee that is to look at this issue and decide whether it makes sense, and if it does make sense, what should it look like? But at the same time, we're trying to do it before the committee even exists. So that's a concern that we have. We've also looked at this and thought a lot of this language under the net public benefit provisions of the bill looks a lot like what a site evaluation committee might do. And that's not what DES is. DES is not a site evaluation committee. We're a permitting authority. We're a regulator. And so our view is that if it were the will of the legislature to have this more expansive review of net public benefit, then that seems to us to be perhaps more properly housed under something that looks like a site evaluation committee that might well be outside the agency.
So last one, Mr. Chairman, for me, thank you, and thanks again, Mike. So do you have the amendment in front of you?
I do.
Yeah. So it's kind of the same question I had to Mr. Sandal about how would you look at this? Because I first saw it and said, well, does it mean then you've got to search around the state at any potential piece of land and do a full analysis of it as a potential site for a landfill? Or would you, how would you see this?
Sure. Well, and I appreciate the question. So, and to be clear, I think it's been discussed, but I want to make sure people understand the current requirement for an alternatives analysis is solely housed in the wetlands rules, without regard to the type of facility that's being proposed to cause a wetlands impact. And my understanding, I'm not an expert on that, so I'm not going to comment too much on that, other than to say that that review is really to determine, for the proposed use that you have, is there another site or another way of doing things that would result in a lesser impact on wetlands specifically? And of course, that analysis and discussion was done, and there may well be, as one of the other folks who testified mentioned, there may be problems with that. I don't have an opinion on that because I'm not a student of it in the wetlands program. I don't really know. What this would do, as I understand, is entirely different. It would, as I read it, it would say that an applicant has a responsibility, an applicant for a solid waste facility permit, for a landfill permit at a new site, would need to evaluate other sites in the state that might also be suitable for a landfill. And then it appears do a full net public benefit analysis on those other sites. And maybe there's a couple, I don't know how many there might be. And then compare those, and then presuming that you had enough granularity of how that works, determine whether another site is more appropriate. It strikes me that it's a little bit notional in the sense that, you know, typically when a landfill applicant comes to us, they've got a site that they have an opportunity to either already own it or they have an opportunity to own it. I don't know whether they would only be required to do an alternatives analysis for other sites that they could own, or whether they could just look at a lot that, you know, a big parcel that nobody has an interest in selling them and do an analysis on that. I have no idea. So there's a lot of, you know, a really lack of clarity for us for this amendment. We don't know how that would be implemented. And it occurs to us that if that happened, it could, you know, significantly increase our work, which if that's the will of the legislature, that's what we would do. But it could mean we would be actually doing public benefit analysis on conceptual sites in addition to the site that's being proposed.
That was my understanding as well.
Yeah, and just, I mean, in terms of what you've been saying there is that, on the one hand, the alternative sites, you know, why we had the answer from Mr. Sandal was that, hey, that's wetlands, right? But this doesn't specify wetlands issues. So it does seem to open it up broadly. And then you get down to line 9 where it says 10A, and you look at 10A, and I mean, that's public health, welfare, and environment, and that's not limited to wetlands. So this is, to me, would be, you've got to look at every other 500 acres in the site, whether you own it, in the state, whether you own it or not, and see if it might be a better place, or, I mean, I just,
yeah,
and that's why I'm asking.
It's not clear to me. I mean, one thing that is clear, it's amending RSA 149.9M9. So it's clearly about solid waste facilities.
Yeah, okay.
So we would see it as a very specific and direct mandate to conduct that review for solid waste applicants.
Thank you, Mr. Chairman. Thank you, Mike.
Thank you. Somebody had mentioned that, I don't know if it was you, maybe it was, but that this could interrupt current applications that are already in process.
Well, and again, one of the reasons that the agency, the main reason the agency is not taking a position on this and not providing direct testimony, at least not in a written form, other than to answer your questions, is that we do have an application pending before us right now that could be impacted, by provisions within this bill. And so as a result, consistent with our position on a number of other bills that are in play in the legislature right now, we're not taking a position on this bill.
There was also a statement about transparency to the public as far as these applications. Can you discuss that a little bit? I mean, is there an issue with that, with transparency, with the public notices and information that's out there so that the public can be engaged in the conversation?
And I apologize, I was not in the room for the first part. I was trying to listen streaming outside, but it was a little bit noisy, so I'm not sure I heard everything. But with respect to transparency generally, DES endeavors to be as transparent as it possibly can be with respect to all of its work, including its review of solid waste permit applications. We do put up submittals and correspondence available on our website so that any party who's interested can easily access it. We do conduct, obviously, the required public hearings for appropriate applications. But we also, when there is an interest, a specific interest in a project that is, more significant than normal, we will hold public information meetings, and that's been done with regard to a number of permit applications that were in play for the Granite State Landfill project, which has been discussed here by others. And we have done that. We typically, when there's a lot of interest, we will hold a public information meeting, which the statute does not require, but we think it's helpful and appropriate. One of the frustrations for people is when we hold a public hearing on an application, it's really very specifically for the purpose of taking testimony on an application that's before us. And we don't really engage in a lot of back and forth with them. And, when someone gets up and speaks passionately for 10 minutes about something and the only response they get from the agency is thank you for your testimony, it's pretty unsatisfying. And so what we try to do in cases like this, or in case of significant interest in an application, is prior to the public hearing, we schedule a public information meeting that is a lot more back and forth. We try to do a little bit of a presentation to help educate people on what exactly is before us and how we review it, and how we review these applications and how the rules apply to them. And then we engage in what in some cases is several hours long back and forth questions and answers from the audience, which we're happy to do. We really, our staff really want to serve the public, and that gives them an opportunity, the experts on these things, to answer questions and have a back and forth so that people understand how we're doing our work. And we're available to folks. I know that sometimes there's some frustration because when folks comment on a pending application that's before us, our ability to really engage in a back and forth freewheeling dialogue on that is sometimes limited because it puts us in a position where it could appear to either party that we prejudge the application in one way or another. So when we're engaged in the review, that back and forth is a little bit more limited. But we do the best we can to be as transparent as possible.
Thank you. With regards to the fiscal note, it says it's indeterminable. Now, if you had to take on these additional responsibilities, would you have to hire staff? Would you have to, what's a ballpark, like, oh my gosh, this could possibly be added to?
Well, and I did hear one other person's testimony that suggested that the fiscal note, the department saying wouldn't necessarily increase costs was probably incorrect. And I would have to agree. I think looking at this, to be fair, we get these fiscal note worksheet requests and we usually have very little time to turn them around. So we don't always get it 100% right in the first cut. I do think that if passed as proposed here, we would very likely need to spend a lot more time on our public benefit determination work, and that might mean the need to, hire an additional staff member, or frankly, and that would probably be more expensive than hiring a staff member. But depending on what issues we were asked to evaluate, we may have to be able to hire contractors to do certain kinds of reviews.
And would that impact the cost for the application?
Currently we have by rule set application fees. I think they probably need to be revisited anyways, but we would probably revisit them with respect to any additional costs associated with this. If the legislature were to pass a bill that required us to do these kinds of reviews, the agency probably feels that it would be appropriate to allow the agency to hire contractors at the expense of the applicant to conduct those reviews, and that would take some pressure off of the state resource impacts.
Thank you for your time and for your testimony and for being here. Any further questions from the committee? Seeing none. Does anybody else want to have a last word on this? Good. Thank you very much, Mike. Appreciate you being here. Let's see.
Alex, you feel a little warm in here?
Yeah, I'm warm.
Window up a little bit, or is
Yeah.
do you think that one could go up just a little bit, that window? I don't want to freeze Senator Gray, but
Definitely.
It's kinda
if you
stuffy
can-
in here.
If you can send the committee report to, just on this hearing, to send.
The hearing report, you mean?
The hearing report, yeah. To both Senator Bradley and Hennessy. That'd be greatly appreciated. Just,
Yeah.
if you can have
all
that,
right, well,
because I think it's really important for them to hear what's
Okay.
going on. All right. Senator Bradley, you're welcome to start whenever you want. And we're going to open up the hearing, SB 424 FN, and hear from the prime sponsor, Senator Bradley. Welcome, Senator Bradley. You have the floor.
Thank you very much, Mr. Chair. Oh, boy, I brought the wrong folder down.
You want mine?
Nope. So now this is a test of how well I can remember things, because I don't have my notes. And I have a room full of people behind me that are probably shooting daggers at me because I don't have my
No,
notes.
every single one of them's in support. Every single one.
And they're probably wondering if they're gonna have to pick up the trash when I'm done. That was a,
just no methane.
you're supposed to laugh after the last hearing.
Actually, I have one person who's neutral.
Okay, so. Senate Bill 424. It is an incentive and an opportunity. It's meant to enhance our ability to create renewable natural gas from renewable resources. For instance, biomass, but it could be from other sources, and to be distributed into the natural gas pipeline. I think, as everybody knows, we're at the end of the pipeline in New England. We don't produce enough of our own electricity or power, and that anything that will increase indigenous resources for New Hampshire is a good idea. So that's the purpose of the bill. And so it goes through a purpose statement, because it's a new chapter, a number of definitions, and then it talks about procurement from how it would be structured. So the one question that comes out of this, because I think you're going to hear a lot of testimony about the merits, and so I've already talked about, why we need more resources and diversity of resources that are clean and renewable. But the question always comes down to cost. And there could be a cost, it's hard to say, but the structure of the bill and the amendment, and I'll get into the amendment in a moment, is such that there has to be a public interest finding by the Public Utilities Commission that this makes sense based on all of the criteria: fuel reliability, fuel diversity, environmental impacts, and cost. That's how the balancing test always happens at the Public Utilities Commission. That, here we go. Thank you very much. You're the best. And so when there's a public interest standard, that has to be met in order for something to be approved. And so there is a healthy public interest test in the bill, and it's enhanced in the amendment. And there's a cap of 5%. And so if there are increased costs, it has to be determined to be in the public interest. In other words, the benefits of it outweigh the downsides of it. Okay, that's how utility rate making works. So, now that I have my folder here, I can talk a little bit more about the actual amendment. And the biggest changes in the amendment, and it's Amendment 660. I have an extra one now. Thank you. The biggest changes in the amendment are on the second page. And again, I think it's important to note in the amendment, right off the bat, the commission may approve, so it's not shall approve, it's may approve a petition by a gas utility if it's in the public interest, which is on line 8 to do so. And then again,
Senator, just pause a second. None of us got a copy of that. So it's just going to help.
so you're not the only one who forgot his folder today.
No, I have mine.
I'm feeling good now.
My amendment.
You don't have the amendment.
I have my amendment. Yeah, and I'm trying to look like I know what I'm doing here without the amendment.
February 10th. Should have been distributed. I thought it was. So that may be my fault.
That's all right. But you can still speak to it.
All right.
You know,
So
I'm interested.
again, strong public interest language. The language further goes on to say the benefits of the proposal, and it talks about environmental attributes, carbon offsets, incremental cost, has to be necessary to achieve those benefits, okay? So that it clearly outlines what the public interest standard should be. The amendment also adds a competitive bidding process that wasn't in the original bill, so I think in order to keep the costs low, that's the best way, through a competitive bidding process to make sure that happens. The hard cap is in the amendment. And lastly, the Department of Energy, and I think the Department of Energy had a lot to do in the drafting of this amendment, will study each utility's natural gas renewable contracts after 3 years of the effective date. So there's a ongoing mechanism to make sure that costs and benefits align, how the program's working. Maybe it should be expanded at that point in time. Who knows? I think a lot depends on, where it is, what the costs are, what the opportunities are. Again, it comes back to, something that I think we need to be very cognizant in New England right now is we're at the end of the pipeline. We've got supply constraints, and we need to recognize that. And if we can produce indigenous, renewable natural gas, that's a good thing. So happy to answer any questions.
I had a constituent who was all in favor of this bill, just say, go reverse on me and said, well, Senator, I like the idea, but after 6 years, when all the gas runs out of the landfills or whatever, the cost for this infrastructure that we're going to build is just going to be a waste of money. What would I say to her?
So that's what a public interest standard is meant to achieve. When you have a public interest standard, the benefits of it have to outweigh any of the potential costs. So things like the investment in the infrastructure are going to be taken into account through the process that always happens at the Public Utilities Commission, which is a process that's similar to ours, where you have expert testimony and witnesses and filings in a docket that seek to answer any of those types of questions. And then the Public Utilities Commission has to make a determination if it makes sense, if it's in the public interest. So I think, you know, I don't think we're gonna be at a point in time anytime soon that we're not gonna have landfills and landfill gas. I mean, that's just the nature of how we live in this country. We're one of the most forested states in certainly in America, but also in the Northeast, and so we have a lot of indigenous biomass resources, and this committee has had a lot of discussion about biomass over the years, and I don't think that's changing anytime soon. What we'll have to do, and basically think of this at 5% as a pilot program, utilities are going to have to invest. They're going to have to justify it. They're going to have to justify it on a cost basis, to say nothing of a reliability basis. And if they can't, you know, do that, cost, reliability, and environment, they're not going forward, because that's just the nature of how it works at the Public Utilities Commission. And so I don't think you're going to see a lot of stranded infrastructure as a result of this bill. And those are the kind of questions that get fleshed out in a proceeding at the PUC.
Thank you very much. Any questions for Senator Bradley? Really appreciate your time, Senator.
Always a pleasure. I'm
Thank you.
sorry for
That's all right.
not having
We
the right
appreciate
folder.
that.
I did bring my mask, but not the right folder.
Seeing no further questions. Kat Burke and Huck Montgomery, would you like to testify? All right. The dynamic duo.
We try, Senator.
All right. From Unitill and Liberty.
Thank you, Mr.
This is a
Chairman.
bipartisan testimony.
Thank you,
All right.
Senator Avard.
All right, welcome.
For the record, my name is Kat Burke, and I'm the Director of Government Affairs at Unitill. With me today, of course, is Huck Montgomery, the Director of Government Affairs at Liberty. We are here today in support of the bill as introduced and as amended by Senator Bradley with 0660S that he introduced today. I think that Senator Bradley accurately captured all of the benefits of this bill, and I think for the most part, Huck and I are here to answer any questions.
You had the amendment up with your.
Yes.
Oh, good
Yes.
for you.
She brought a copy. She's very.
Couple
You got connections.
I think the one slight clarification that we should make is under the amendment, the utilities would actually not be permitted to invest in the RNG infrastructure itself. So if you're looking at, on the amendment line 30, on the RNG infrastructure, it's the equipment and facilities necessary to receive and inject the RNG into the pipeline. You'll notice that that was a difference from procurement and production in the bill as introduced. So that is something that was fixed by the amendment as well. But essentially, we feel as though that this is an appropriate step in the right direction in the future of the gas system here in New Hampshire and beyond. We think that this bill is all-encompassing in, accounting for technologies that are available now and will be available in the future under the definition of RNG. We've worked closely with DOE, as you mentioned, to make sure that proper guardrails are in place with a hard 5% cap, a very robust study that DOE is going to have to conduct after a couple years. And we think that this is in a good spot, and we're happy to answer any questions.
Again, for line 30, you said renewable, repeat that again?
Yeah, so if you're looking at the bill as introduced, I'm not sure if you have both copies in front of you.
Yeah.
But renewable natural gas was defined in the original bill as introduced, sorry, one second, on infrastructure, page 25. Or excuse me, line 25 on page 2.
No, I don't have 25 pages.
Sorry, I hope I don't either.
Page 2.
Page 2, line 25, you'll see that RNG infrastructure originally included production and processing, as well as transportation, et cetera. That is streamlined in the amendment on page 1, line 30.
Okay.
So the utilities would not be investing in the production aspects of RNG, and again, that's another cost containment mechanism.
Senators, I just want to say I appreciate all the hard work, the sponsors, Senator Bradley, the other sponsors, the
bipartisan list of folks who are on this bill have put into it, and as well as all the hard work that the staff at the DOE have done to put this into the amendment together and to really hone the policy that the legislation's establishing. And I think a lot of hard work has gone into it. It shows, and it's something that we're very happy to support. So
there's an amazing amount of sponsors on this. There's no doubt. Senator Waters.
Thanks, Mr. Chairman. And thank you. And Huck, I have a paper copy of the CLF letter. Would that help you if I gave you a copy of it?
I've got it here. Kat, do you want a copy of that?
No, I can look up what we shared
All
as well.
right.
Yeah, thank you very
Okay,
much.
well, anyways.
Was that your question?
So, here's my questions. There's a couple things in here, and I know I'm going back and forth between the original text and the amendment, but I just wanted to get your responses to. So, they raised the cost issue for this kind of gas. They cite the $10.47 per decatherm versus Liberty's Peak of $3.20 per decatherm. And I just wonder if you would respond to the notion of what is likely for this gas is going to cost.
Sure. So I think to Senator Bradley's point, the de-risking aspect of the amendment that was brought forward really addresses this directly, right? It's not, the bill isn't intended to, get any particular project or any particular pathway approved. And so Liberty's filing that has gone before the commission today and anything that would move forward in the future is going to be subject to this very robust public interest standard and RFP process. And so it's not going to happen if it doesn't pencil out as being in the public interest according to the commission. So we think that the amendment really covers that issue.
Yeah. Then the next question I wanted to follow up on was, it was actually in two places, the concern about leakage and biogas supply chain and transportation and so on and so forth. So that, this notion of what are we really counting when we're thinking of CHG emissions avoided. And, they had proposed a couple of places where under the carbon offsets language, there could be something there that would include accounting for leakage and so on and so forth. And then they also had suggested that under the, again, page 3, lines 3 to 6, on the benefits would also include some reference to the life cycle emissions of the proposal, including methane leakage and so on. So it's in a couple places, but the basic question is about, how is that benefit being calculated, and does it include and we all know there's some leakage and so on and so forth. So how would this, what's your response to that notion of maybe adding something to it?
Well, sure. So, again, I think that the amendment really addresses that directly in terms of what is the public interest. And so that's, again, a robust test that's going to take into account the energy strategy of the state of New Hampshire and sort of all of the policies that are, that are in place in the state. And if any proposal the utility brings forward doesn't advance that energy policy that you all have established, right, the project's not going to end up getting approved. So the extent to which any factor is important to the public interest, it's going to be weighed heavily. And so we think that really is kind of accomplished in the amendment. I will say that certainly looking at the actual avoided emissions, to the extent that that is what you're trying to achieve, and the energy policy seeks to achieve that, absolutely, the actual avoided emissions is important to look at for sure. But again, I think the amendment that's brought forward really addresses that head on with the public interest standard.
So could you, we can talk after the hearing, but could you take a little closer look at the second place where they talk about this under the public benefits part? The benefits of the proposal utility, customers of the state, including but not limited to any monetary value, non-monetary benefits of the proposal, such as the value of any environmental attributes of carbon offsets, and then they suggesting which fully account for the life cycle emissions of the proposal, including methane leakage during processing and transportation emissions resulting from supply chains. I mean, I don't think it's a whole lot different from what you might do before the PUC, but if you would think about maybe some of that wording seems possible, maybe that would be appropriate.
Yeah, I think first time we've seen it today,
yeah,
we'll definitely take a look at it, and we can happy to have that discussion for sure.
And then if I may, Mr. Chairman, another one. And then this issue about the to the extent the proposal is consistent with the New Hampshire Solid Waste Management Goals and Waste Management Hierarchy in 149 M11-3, and, you know, I mean, this, I think that's trying to button up the relationship here. This is a gas bill, but what is the relationship to the waste management? So, have you any thoughts about that one?
Yeah, I was just going to say, I'm just looking at that right now.
Yeah.
I'm not familiar with that particular section of statute, so I wouldn't know whether or not that ties in here nicely. But I do think that, I mean, we can certainly take a look at that. I do think that, you know, proper waste management and effective use of waste streams is captured in the goals of this bill as an overarching theme. I think that that's captured here already, and I think that that would be something that's in the public interest anyways. But I do think that we could look into.
Yeah, I just, thank you, and I just mentioned it. I mean, do take a look, because the goals there, and then the picture of that hierarchy, and what are we trying to do with solid waste in general. I think it's just asking you to touch base there, but take a look and see what you think. And then lastly, the question about, you know, we've had a little conversation about costs already, and you mentioned the PUC process, but here, the last thing they suggest about the 5% threshold, and they are saying 1% annually adjusted for inflation rather than 3% annually, and I don't know what you had thought about that one.
Yeah, so I think if we're looking at, I think this letter from CLF was drafted based on the bill as introduced.
Right,
correct?
I mean, that's the problem. I told them that. And,
right, so if
yeah.
you're looking at the new amendment based on, or compared to the original bill as introduced, in the original bill, there was a provision with, I'm calling it an above and beyond test, right? It would allow the utilities to go above a certain cap threshold if they could prove the public interest test that's laid out in the bill, in addition to several other factors that would make this a very robust, you know, high hoop to jump through, correct? So that was actually removed in the amendment. So the new amendment puts in place a hard 5% cap. There's no ability to go above and beyond. So I can certainly understand some more parameters for an above and beyond test, but since that's removed in this particular piece of legislation, I think that the guardrails are really in a good spot to make sure that, you know.
Yeah, I agree.
Okay.
I see that. I think that is moot now. It just, I was shuffling, just got this morning and shuffling things around, so I wanted to go through them. And,
yep, that makes sense.
And so I think I'm good on those, and just, you know, so really it's just that it is the one there, maybe take a look at the couple of them. They're on page 3 of the letter, and we'll talk.
Great.
All right, thank you.
One of the things I like what's happening right now is the fact that this is all being recorded and people can see what's going on here. I really like that. But for the general public's interest, can you just tell me the whole idea of what's going on in very simple layman's terms? What are we doing here with this bill?
Sure. So very simply, what we're trying to do is take waste streams that are currently occurring and use them for energy.
So like gas at a landfill where there's a whole bunch of methane trapped inside, rather than it leaking into our system, turning that into energy. Do I have that concept correctly?
You do, because natural gas is almost all methane. That's what it is. Methane is a really energy dense, valuable fuel. That's why our customers want it. And so if you can make that same methane, that same fuel, but be able to produce that locally from waste streams, you can create value streams for the entities that are currently producing that waste, where maybe before you had to pay to get rid of your waste. Now you can turn that into a value stream for yourself, and then customers of the utilities can actually get that renewable, locally sourced energy, and they can get it year-round according to the production curve of whatever that production facility is, and not be at the whim of the interstate transmission system of natural gas, right? Which Senator Bradley was talking about. We're at the end of the pipeline. Right. So that subjects our customers to a lot of volatility in the price and the availability of natural gas. And on a day like today, the spot price of natural gas is very high. We're talking about, in the 2014 polar vortex here, you had $100 a decatherm natural gas, and going price these days would be like, what, $3, $4, $5 on a normal day? So if you're able to produce that fuel locally instead, and you don't have to buy that really, really expensive gas on that peak day, it provides value to the customers, as sort of insulating from that volatility and taking it, really kind of securing a measure of energy independence from that constrained system.
So just kind of a little follow-up on the leakage thing. It's already leaking into the air. And so what we're trying to do is capture
That's right.
that and turn it into energy, so that waste that is producing all this gas going into the air, we got a good idea, we're gonna turn it into energy, so it doesn't pollute the air, doesn't add, that's the concept of what we're doing here, right?
Yes, sir.
All right, thank you. Senator Gray, any questions?
Just a question.
You might.
Don't we actually burn some of it because of smell requirements?
Some of it is
instead
flared,
of just
that's
releasing
correct.
it?
Yes.
Yeah, in that case, so you're taking what could have been useful energy and you're just burning it. And
That's what we used to
not
do with the
really-
bioplants.
Right.
All right.
So putting that
little
to
plug.
use instead is a very valuable thing. If you have to think about it, Senator, if you had to build a stack to flare the stuff and you get nothing in return out of it, instead you could build a production facility for RNG and you could get paid. So that's the idea.
Thank you very much for clarifying that for us. Appreciate it. And now we're going to hear from the distinguished gentleman, Mark Brown.
Thank you, Senator.
Thank you.
Thank you. You have the floor, Mr. Brown.
Thank you. Thank you, Mr. Chairman, members of the committee. For the record, my name is Mark Brown. I'm the Executive Director of New England for Consumer Energy Alliance, or CEA. CEA is a nationwide association made up of energy producers and consumers working to advance an all-of-the-above approach to energy and environmental policies. We believe that responsible policies always consider the need of consumers while leveraging and supporting the development of state-of-the-art technologies to improve our environmental stewardship and aiding in the reduction of all emissions. Excuse me. On behalf of CEA, I want to thank you for the opportunity to testify today and on Senate Bill 424 in support of Senate Bill 424. The bill, it's a forward-looking bill. It'll help prepare New Hampshire's LDCs, the gas distribution companies, for what the future of the gas system may look like. The bill and the amendments, it's a prime example of how thoughtful legislation can balance competing public interests. The provisions in SB 424 will result in a cleaner natural gas system with lower emissions and ancillary benefits like cleaner wastewater streams and reduced deposits into landfills. SB 424 will also help to ensure reliability of the natural gas distribution system and preserve consumer choice by insulating New Hampshire consumers from actions taken by both neighboring states and by the federal government that may ultimately limit access to natural gas. Additionally, the 5% cap in PUC DOE review and study will protect consumers from any potential and excessive rate hikes. Renewable natural gas, it's going to play an important role in our energy transition as we continue to advance efforts to reduce emissions and without negatively impacting the affordability and reliability of the system. So I want to speak to the wastewater, the solid waste issue. So you guys should have received testimony last night from one of our member companies, Purpose Energy. They are involved in anaerobic digestion. So they'll take, solid waste, turn it into biogas. But one of the things that they do is, they have a facility at Smutty Nose. And the reason why they installed the facility there is because the Hampton wastewater treatment plant couldn't handle, the effluent wastewater coming out of the Smutty Nose. So Purpose went in, installed their anaerobic digester, cleaned up the waste stream, made it manageable for the municipal water treatment plant. And in that process, they create biogas, which is used, I think they have a heating system that uses the gas right now. And yes, I do believe they may flare a little bit of it, but I think that's more of a pressure-related thing than anything else. So that's one example of what can happen, through this process and creating a market, and it'll incentivize private, investment in private capital. So just wanted to comment on that really quickly. So other than that, I'll be happy to take any questions.
Questions from the committee? Seeing none, thank you very much for your testimony. Mr. Kreis? Office of Consumer Advocates.
Yes. Good morning, Senator Avard, Senator Waters, Senator Gray. As you know, my name is Don Kreis. I am the state's consumer advocate, and by statute, it is my job to represent the interests of the state's utility customers, residential utility customers, including the customers of our two local gas distribution companies, Unitill and Liberty. And Senator, as you acknowledged earlier, I think I'm unique on the roster of witnesses today in that I neither support nor oppose Senate Bill 424. I am, like you, impressed by the all-star and bipartisan roster of sponsors from both chambers. Seeing Representative Vose and Representative Somsich on the same bill is shock-inducing for somebody like me. We need in New Hampshire, I want to acknowledge this, New Hampshire needs natural gas, and it needs our natural gas utilities, meaning the local distribution companies. And we support the efforts of those utilities to sell renewable natural gas, and we like the definition of natural gas that's in the bill. Ideally, legislation encouraging natural gas distribution companies to offer renewable natural gas to customers would, in my opinion, do two things. It would tell utilities to offer renewable natural gas as an option for those customers willing to pay the premium price of that natural gas, and it would hold other customers harmless. And number two, it would not migrate business risk from utility shareholders to utility customers. And in that regard, I have to say that although I haven't seen the amendment that Senator Bradley and the other witnesses have been talking about, I like what I heard about that amendment because I think it addresses that second of the two concerns. We learned our lesson from the Seabrook-induced bankruptcy of PS&H in 1998. On the electric side, generation facilities are no longer in electric rate base because the risk that a generator will prove uneconomic is properly left with the shareholders of unregulated companies, not captive customers of electric utilities. And that principle has a direct analog in the world of local distribution companies in the natural gas realm. Neither Unitill nor Liberty presently own any gas production facilities. That is simply too risky to put in rate base to recover from captive customers. And that is exactly what the original version of Senate Bill 424 proposed to do. And if I'm understanding the amendment correctly, that risk that ratepayers would be on the hook for paying the cost of production facilities is exactly what the authors of the amendment took out of the bill. And I think that's really good news. And while I think I'm still going to stay neutral on the bill, within the context of that neutrality, I think the amendment enhances my enthusiasm. Ultimately, it's up to you. You have to, you being the legislature, have to make policy calls about whether renewable natural gas is important enough to allow the PUC to socialize its cost among ratepayers and then to authorize natural gas utilities to make certain investments that are designed to make renewable natural gas a possibility. I do want to add one sort of anecdotal observation, and this has to do with the colloquy that I heard earlier about the desirability of taking gas that wafts out of landfills and not just emitting it into the atmosphere, but putting it to use. Liberty Utilities has, on two successive occasions, tried to get the PUC to approve a contract with a company that would, in fact, harvest the natural gas from the landfill in Bethlehem. And that met with a considerable degree of pushback, both from my office and from what was the PUC staff and what is now the Department of Energy. And on one of those two occasions, the developer said to me, well, Mr. Crease, you know, if the PUC doesn't approve this, then we'll just harvest this natural gas from the landfill and we'll sell it out of state. And I almost said, be my guest, because we in New Hampshire don't want to emit that methane into the atmosphere, but if we can get the ratepayers in another state to pay for not doing that, that's not necessarily a bad thing for the state of New Hampshire. That said, I commend the authors of the bill and I commend the authors of the amendment for doing what seems to me to be a pretty good job of trying to balance the competing policy interests, as I think I heard Senator Bradley say. And so therefore, I think I am suggesting that you approve the amendment that you have before you and then as to whether you ultimately want to cause the ratepayers to pay for renewable natural gas. Just reminding you that the only wallet in the room at the end of the day is that of the ratepayers. I leave that judgment in your capable hands. I think that's all I have to say by way of a direct testimony, but of course I'd be happy to answer any questions.
Senator Waters with a question?
Yes, thank you, Mr. Chairman. Thank you, Don. I know I'm dancing around between the amendment and the original bill, but I just wanted to ask you the statements in here about the public good or the public purpose. I think you probably, I'm really glad. I appreciate the drafters of the amendment attending to my, well, in the original bill and in the amendment to some of the concerns. I had to make sure that we were expanding this purpose statement here a little bit. But what came up in my questions about what the CLF had asked about this question about, are we really sure that we are reducing the life cycle emissions of the proposal and methane leakage? And, if you're in a position of public advocate, do you think it's important for us to make sure that the public good is fully addressing the questions of all the emissions for a project?
Yeah, I do. I typically don't pursue an environmental agenda because I like to leave those questions to the experts, including the folks at the Conservation Law Foundation who have people who work for them who are very astute and knowledgeable. But I will say as a general proposition that I think it is important for the general court to think about the life cycle effects of the natural gas industry. But as I said at the beginning of my testimony, we're not in a position at present to just stop using natural gas as a fuel in New Hampshire.
Not in my house.
Not in your house, not in many houses around the state, and of course not in order to produce the electricity we need. So therefore, the kinds of incremental steps along the way of making the state's renewable gas portfolio more sustainable are a good idea. And yes, we should, of course, consider the life cycle impacts of everything we do, and we certainly should do our best to reduce fugitive emissions of methane into the atmosphere wherever it happens along the production, distribution, and combustion chain.
Thank you for your testimony. Any further questions?
Thank you for the opportunity to visit with you today.
Kristen Koch from BIA in support, not wishing to speak. I guess I'm going to hold Josh at the end because you tend to ask me to do that. Pardon me?
Whatever the chair wishes.
Okay. Rep. Mike Bose is in support. Okay. Jason Stock, are you here? Is this your first time?
It isn't. On this bill it is.
Actually, that's getting old. All right.
Well, good morning. For the record, I'm Jason Stock. I'm with the New Hampshire Timberland Owners Association, and I'll be very brief. I'm here today in support of the bill and the amendment. We see this as a potential opportunity as an emerging market for low-grade wood, using wood chips and sawdust and tree trimmings, using it to convert it into a natural gas product. And so for that reason, we're here in support of the bill. We think this, as the prior speaker had mentioned, this is a pretty progressive, forward-looking bill. And as we look at our situation in the state with low-grade wood markets, this could be part of the solution down the road. And so for that, we're supporting, and I'd be happy to try and answer any questions, but I just wanted to weigh in this morning on it.
Thank you for your testimony. Any questions from the committee? And seeing none. Thank you very much, Jason.
Thank you.
Kelly?
Good morning.
Good morning.
Some written testimony for you. It's very brief. But thank you, Mr. Chair, members of the committee. My name is Kelly Buchanan. I'm Director of Legislative and Regulatory Affairs at Clean Energy New Hampshire. And I am here before you today in support of Senate Bill 424. We see this at Clean Energy New Hampshire as an important opportunity to capture existing sources of methane from waste streams in New Hampshire. And we see this as important for a variety of reasons, but this does help promote our energy independence and plays an important tool in diversifying our local energy landscape, and especially for something that's existing and provides an opportunity to capture that and to make good use of methane that's already, going out into the atmosphere. That is a good solution. And while we see that renewable natural gas doesn't quite have the same potential as other distributed energy resources like solar, hydro, or wind for long-term clean energy solutions, it does play an important role in transitioning to a clean energy economy and providing value to the state of New Hampshire in terms of that transition. So I'll be very brief. I'd be happy to take any questions if you have them.
Questions from the committee? Seeing none, thank you very much, Kelly.
Thank you.
Appreciate it. And Josh Elliott, do you have any, you're the last speaker unless somebody else wants to speak on this particular bill? But
Good morning, Mr. Chairman, members of the committee. For the record, Josh Elliott, Director of the Division of Policy and Programs of the Department of Energy. The department is neutral on the bill as well as the amendment. We view the amendment as a good step forward in terms of the legislation itself. Before I get into the details, I think the department tremendously appreciates both Senator Bradley as well as Kat Bork and the other advocates working with the department to address our concerns with the original bill as introduced, and that you see most of that in, or I should say you see that in the amendment 0660S. We have a couple of small changes to the amendment that we're going to suggest, and daily I will follow up with an email to make sure you get all of these in case the committee decides to move forward on them. So if you're looking at the amendment, I'm going to bounce around a little bit, just it's more thematic rather than line by line. So I'm going to start on line 18 on page 2 of the amendment, on where it says Roman 3, where it begins all utilities. And we're going to suggest inserting the words that elect to purchase renewable natural gas, and then continue with the rest of the sentence, shall conduct a competitive bidding process, etc. There was a concern after we looked at the amendment that it made it appear as though there was a mandate for utilities to purchase renewable natural gas, and this is just making it crystal clear that it is elective. It is not a requirement to do this.
that one more time, Josh?
Sure. So I'll read the sentence in its totality. So it's page 2, line 18, where it begins with Roman 3. All utilities, inserting the language that elect to purchase renewable natural gas, shall conduct, etc., and continue as currently written.
You got that, Daly? And you'll follow up with an email too.
Yes, yes.
Yep.
The next change, I'm going to bounce back up to line 6 because it's continuing just to with this same theme. Page 2, line 6, to insert the word prudent so that the sentence reads on line 6, cost related to prudent utility procurement. And then on line 11, still on page 2, under subsection A, to read the inserting the word monetary, so it reads the monetary benefits of the proposal. And then on still on page 2, line 31, this is just a clarification in terms of the funding mechanism to actually fund this study that the department will be conducting on renewable natural gas. So that on line 31 it reads, the cost of this study shall be funded by, and inserting the words special assessment upon, and then continuing the utility or utilities purchasing renewable natural gas.
One more time on that, the cost of?
Sure. The cost of this study shall be funded by, and then inserting the words after the word by, special assessment upon, and then continuing the sentence so that the whole sentence reads, the cost of this study shall be funded by a special assessment, actually it should be by a special assessment, by a special assessment upon the utility or utilities purchasing renewable natural gas, etc.
Good. All right.
And with that, I will be happy to take any questions.
Senator Waters.
Thank you, Josh. On the recommendation on page 2, line 11, how wedded are you to that delineate or monetary?
I think I would have to check with the other folks at the department as to whether or not that is a make or break for them. I think there's the concern that if we just talk about benefits in general, there's no way to really quantify other than a sort of a monetary way of doing it. Again, being a financial regulator rather than an environmental regulator.
Yeah, I guess that, I mean, there's two things here. One is that there are other parts of the bill that just reference environmental benefits. There are several other places in the bill, the public purpose and so on. So this would seem to circumvent that. And then the second part of it is that, you know, there's a lot of discussion about how do you quantify, for example, you know, I mean, we have quantified the $400 million in health costs to fossil fuels in this state, the people in this state for health, right? But and great, I'm all for health. I'm for healthy environment, reducing carbon, et cetera, et cetera. But if it were here that you had to calculate, you know, exactly which people and so much and so on, and I just think I'm just making a case rather than a question. So I say, wouldn't you also maybe try to check out and see if it might be useful to think this way? That you know, for a lot of folks, it's a broader environmental benefit, which is not quantifiable just in the word monetary right there. So I just personally think that it's unnecessary. I also think it contradicts some of the other language in the bill. So if you're not totally wedded to it, unless I hear from the utilities that, oh my God, we forgot that word, it's the most important thing here, maybe we don't open up that can of worms.
No, and I think that was a request of the department to add monetary back in, so I don't think there would be any objection by the utilities, although I'll let the utilities speak to that. I will check with the folks back at the department just to make sure that, again, that is not a sort of a make or break kind of word.
Good. All right.
So just for the record, the utilities are okay with that?
Yeah, we're okay with the changes that Josh suggested. I just would say for Senator Waters, the original bill as introduced said monetary and non-monetary. We did streamline that with the department just to include benefits because we thought that was more all-inclusive. Adding the word monetary back in would be okay, but we did, you know, strike those for a reason.
So if I may ask, is there a problem with saying then on the line 11, the monetary and non-monetary?
Josh, is that a problem with you guys?
Maybe.
Yeah, no, I think putting that back in as it was when it was introduced to include monetary and non-monetary would be fine with the utilities, but of course, it would also have to be okay with the department as well.
Yeah, so just check it out. Anyways, it seems to me something that it would be just lovely for the Department of Energy to not be so exercised about everything's got to be in dollars, or those lousy environmentalists will start, et cetera, et cetera. So take it from there.
Yes, I will bring that back to the department. I hope to get an answer for you on fairly short order on this. I realize we've got a lot of bills to hear and a lot of things to work through. So.
Run that by Jeb too.
Yeah.
I will do that as well.
You know, whatever. We'll see.
Okay. Any further questions? Any further comments? Seeing none, we're going to close. Anybody else want to talk?
Chairman?
We're all set? Good? Close the hearing on that? And I'm going to take a 2-minute recess real quick before I open up the next hearing, just because I drank a lot of coffee. I'm good, Mark. Grab from the amendments, everybody.
You're, from my bill? Yeah, I've already got it passed out.
hearing? Oh, nobody's here, by the way. All right. How's everybody? You're all ready for this one? It's hot in here, huh? It's hot. Thank you. It's not just me. No, no. You're not having a hot flash. What's your message? Why? He's my tie shirt. Very honest. I can fix that. Yeah, drop the heat completely. Thank you. Yep. Okay. Yeah. Are you going to be testifying on this? Senator? Yes, I'll testify. All right. So you get up here. All right. I'll wait for Senator Waters to get back. Keep this open for now. Is he still on? Senator Waters? We'll be back. Okay. I guess you'll be the chair for a minute. Okay. I'm not going to take any questions. I'll let, you got the amendment for this next bill, correct? All right. No, that's fine. I'm talking to you. I'm at work. It's cold now. That's for sure. Yeah, I'm sure it does. Actually, I look like an old man. What's that? Freezer out there in the sauna in here. Yeah. Yeah. All right. I'll wait for Senator Waters. And... Oh. It wasn't me. I'm really gentle with the gavel.
All right, we'll reconvene the hearing on Senate Bill 269 and welcome back the prime sponsor.
Thank you, Senators. For the record, I'm Senator Kevin Avard, and the reason we convened originally was because OLS apparently had drafted this legislation in the wrong section, so we basically have a replace all amendment and establishing a commission to study energy-saving weatherization programs. And that's the extent of my testimony because we have people here to testify specifically about the guts of the bill, and I would refer to them, so if I could do that. Thank you.
Yes, you may.
All right.
And the first one on the list is Senator Flagman.
Thank you, Mr. Chairman, members of the committee. Should I take anything in the fact that usually people say there are smarter people behind me that are going to speak, and you didn't say that?
I didn't, but you can.
Okay, what happened with the original bill, as you said, was that OLS had made some mistakes, but in the end, it actually worked out to the best because it got all of the parties to work together. And after sitting with the Energy Department, Eversource, and everybody else that had something to say about the weatherization program, we came up with the idea that we needed to have a commission. We say a commission because we want to make sure that there's various people there, and we want to make sure that we're able to continue it even if there's election issues for some of the members. So as you see, we've tried to include everybody on it. What it does is it looks to see how we could best afford to continue our weatherization project. Now, the cost of energy savings is going to be, well, the cost of energy is going up to about $100 a barrel just for oil, according to what I heard this morning. So for every poor person out there with a building or a house that's not very energy efficient, that's more money. And as we all know, we put money into a fund to try to help them to even buy the oil. And it's time to reverse ourselves. We still need to help them, but we need to go in there and try to conserve what products we have by weatherization. So as you can see in here, we're looking to see how we can better use the process we have. We found out that oil and propane don't contribute at all to the weatherization fund, but yet they are a big user of the weatherization fund, and it comes out of the electric side. Natural gas has a fee, and I guess that fee stays with the natural gas, but everybody needs to participate. And as you know, I'm not one for taxation, and I'm not one for commissions, but every once in a while, we actually need one. And I think that this one will allow all of the stakeholders and all the people with all the information to actually participate, sit down and find out what the best way is, instead of coming in here every year saying, let's take it from here, let's take it from there. Let's find a way to fund it permanently to the satisfaction of all. I'll take questions.
Senator Waters.
Yeah, thank you, Mr. Chairman. Thank you. You know, I like the idea of the commission. There's a lot here to do. I mean, I work with I know senators in Massachusetts who are working on their bill, and they're proposing 100,000 buildings a year who get weatherized down there, and they're putting some big money in it. We're not going to do that, but it's pretty clear it's a major strategy. And the question I had on this was on line 19. It says weatherization of buildings heated with delivered fuels such as oil, propane, kerosene, and wood, but not electricity. And I guess I don't get it, because electricity is being produced, you know, a substantial portion of it from natural gas, or sometimes coal, sometimes wood. And if we reduce the, if we improve the weatherization of somebody who lives in an electric home, you know, the electricity is they're going to save money too. So I don't know. Is there any reason why it's not here?
I think it was dropped by OLS, but I'll take the blame, because if you go down further, we talk about in the same manner as electric and natural gas. So I think that we need to put electric in there as well.
Where would we put that?
In the same line. Let's try to get all the methods that we use to produce.
Do a committee amendment.
Yeah, and I guess, you know, I mean, it doesn't have natural gas here either. So what about all fuel? Well, anyways, we'll figure it out.
Yeah,
I'm just glad there wasn't a reason.
You know.
I mean, I can see why they wanted to focus here on delivered fuels, because, you know, the folks who are getting propane delivered, they're getting hammered if they're in an unweatherized building. I mean, I get all that, but especially when you get to the mill buildings, they're not going to be heated with propane, right?
There you go. One of the things, Senator, was that we know that natural gas has a fee that's attached to theirs and the money stays, and we know that there's already a fee on the electricity, but you're right that we should put them both in there because they should be part of the discussion, if for no other reason than to not expand them without their knowledge.
Could all fuels work?
Well, it's not quite fuel.
Yeah, so electric and gas, natural gas, yeah. Okay.
Yeah, so delivered fuels, and then maybe add, you know, delivered fuels and we'll figure out the wording. Exactly, but. You know.
For the record, Eversource and Liberty have been working with us to try to find a solution, so.
Also on line 31, there was two members of the Senate. Are you okay with one?
I'd be better off with three.
Just come.
I know it's election time, but I also know how important it is, and I'm not saying that if you're out campaigning you have to show up at every one, but there may be some where you want to be there. So if you want to change it to one, that's fine. I was a senator once. I get it.
We do one.
But, you know, Senator Waters would be an important addition.
But not as important as Senator Abar.
I'm just a little guy. Okay. Any further questions? All right. Seeing none. Thank you, Senator Clegg. Matt, do you have any kind of comments that you want to mention? I know that you're in support of it. Mr. Mayberry? You don't have to really talk specifically about anything, but just as your support for it in general.
Good morning, Senators. My name is Matt Mayberry. I'm the Executive Director of the New Hampshire Home Builders Association, and we very much are supportive of this. Please consider passing it, and thank you for allowing the amendment. We want to expand how we help our Granite State neighbors, especially those with the lowest economic abilities. They're the ones we should be doing this for, and this allows us to do so, and if you'll enable us, we'll do you proud.
Great.
Thank you.
Questions? Seeing none. Thank you. Henry Baylor wants to speak on this. Is he here? Welcome, Henry.
Thank you.
You changed the color of your hair.
Thanks. Good morning, Mr. Chair, members of the committee. Henry is testing, my name is Karen Susi. I work at Sheehan Finney Capital Group, and I believe I am here representing the community action programs.
Yes, you are.
Thank you. So it's my understanding that we have not seen the amendment, but Henry Bayou did email the chair, and we are requesting that that entity be included on the study commission.
The entity?
The Consumer Community Action Program, excuse me.
Okay.
Thank you.
You got that, Daley?
Community Action Programs.
Anywhere in particular on that?
Not.
Somewhere in the bill.
I don't believe it was specified.
Roger that. Okay.
Thank you.
Any further questions? Seeing none, welcome. All right, and let's see. Josh, did you want to talk?
I will. Sorry, over here. Just briefly. Good morning again, Mr. Chairman, members of the committee. Again, for the record, Josh Elliott, Division of Policy and Programs for the Department of Energy. I just wanted to point out that the fiscal note that was originally attached to this bill is no longer valid because it is a study commission. We greatly appreciate moving forward with the study commission. Appreciate the advocates coming to speak to us to get a better understanding of our own weatherization program, and just in reference to make sure that the program is not under threat from losing funding. I will say adding the community action agencies or the community action programs would be a good idea, given that they are our subcontractors for doing all of, or subgrantees, I should say, for all of the federal weatherization money that flows through the state.
Great. Senator Waters.
On that, Josh, who should make the appointment of that community action program person?
That is a good question, because there's several of them, but there's not really any. I would defer to Karen Susi on that question. I know in each of the individual caps has their own has their own weatherization person as well, so it's not.
And so there's no statewide organization.
Not to my knowledge. I
So
could be wrong.
We'll just say the governor.
That I think
I would think. And so how should we phrase it?
Well, you just got replaced.
One member of what's the?
I guess I would one member representing a community action agency or community action program. Would you prefer program or agency? Because I know that half of them do half and half do the other half of it. If you put community action program, they'll.
I'll say or
because
agency.
everyone refers to them as CAPS. So if you do community action program.
Okay, community action program appointed by the governor. Okay, thanks.
Okay.
All right. Any further questions? No, I thought your finger go up. Did you go up? No? Okay. Karen? Picking on you, Karen. All right. Seeing none, thank you very much.
Thank you, Senator.
Anybody else want to talk? Going once, going twice. Closing the hearing on this. You want to exec it? Let's exec it. You okay with execing this?
The second, with enthusiasm, Senator Gray.
All in favor, say aye. Any opposed, say none. All right. So, committee amendment.
So the reason for my hesitation is that I'm going to be debating with a English professor over, delivered fuels and other things.
I got a suggestion. But
All right, I'm ready to listen.
I want to make somebody who actually knows the practical effects of words to edit what the English professor says. So I would say on line 19, okay, weatherization of buildings heated with electricity and natural gas, comma, and with delivered fuels, such as.
Senator Gray.
How did the electricity or natural gas get there? It was delivered. Okay, so again, I think if you take out the word delivered, concentrate on the weatherization of buildings, and then if you want to say such as the following list, then you get away with all of that.
I have to take definition. Is electricity technically a fuel?
It's energy, you know.
I know it is, but I mean,
Is the electricity stored in a battery in a car fuel, or is that just?
that's why we have different energy storage statute.
So the natural gas would be a fuel for that argument. So if you said electricity, I mean,
What if we just said then, what if we said with fuels including electricity, natural gas, oil, propane, kerosene, and wood?
I just want to try to be inclusive instead of exclusive. So, if there's a such as or a,
Okay.
that kind of thing.
All right, let's say with.
Then I think you get there.
How about heated with fuels such as electricity, natural gas, oil, and on we go.
I can accept that.
Okay.
Daily, you got that?
Fuels. No. No. Buildings heated with fuels such as electricity, comma, natural gas, comma, oil, the rest of the list.
Can you just read it back, just what he said?
Heated with fuels such as electricity, natural gas, propane, oil, etc.
Yeah, okay.
And Senator Clegg?
I would suggest that instead of such as, use that lovely legal term, included but not limited to.
Are you good with that?
I'm good with that.
So fuels included but not limited to
Including
electricity, natural gas, yada, yada.
All right, Daly, I'm just gonna keep pounding you on this. How we doing?
Heated with fuels including but not limited to electricity, natural gas, and all nine yards.
Okay, all right.
Okay, and line 31. 1 or 2?
Or one, please. There's 3 House members. So usually if there's 3 House members, 1 senator.
You good with that, Senator?
But I mean,
I'm good with that.
Compromise. Any other changes?
and then we got on line 17, it would be 11, 1 member representing a community action program appointed by the governor.
First page, line 11?
Second page, it would be second page, line 17, it would be number 11. It would be 1 member representing a community action program appointed by the governor.
Line 17.
No, it's not, it would be right after.
Let me
After
try.
line 16.
Let me try.
All right.
You've got a list of up to 10 right now. He's adding an 11 to that list. So on line between 15 and 16, or actually, I guess it's at the end of 16, 17. Then you're going to start with what he's telling you.
Line, it'd be number 11, and it says,
1 member representing a community action program, comma, appointed by the governor. I'll move the committee amendment.
Second.
Third. All in favor?
Aye.
Aye.
Any opposed? Seeing none. And
I'll move on to pass as amended.
Second.
all discussion, all in favor, say aye.
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 Any opposed? Seeing none. And it passes as amended, and I'll take it out, seeing how it's my bill.
Good job.
Thank you. So, 259, that was relatively a simple one.
Which is it?
259? Excuse me. I think Senator Perkins Coker had an amendment for that.
Yeah, and so, Mr. Chairman, the question was whether you and she were going to put together your bills, and I guess that's the amendment, is what you come up
Yeah.
with? Okay.
Yeah.
Good, thanks.
It's basically combined.
And
What we can do with hers is put it into a study.
or retain it to see what the House
Yeah,
does.
exactly. Yep.
Or hold it.
Do you have that, Jim?
I don't think
just
I
gave it to me.
have that one yet. Thank you very much.
Amendment 0242, right?
0242, correct.
So what do we got, Mr. Chairman?
With this amendment, basically, this political subdivision in the state of New Hampshire or any city, town, county, school district, charter, public school, village, and on the housing authority or a quasi-public entity to the Pease Development Authority. And this is basically with Senator Perkins Coker's language to the bill. And more inclusive than restrictive, so I think, I like it, unless you have.
No, I think this is good. I think that what it, the kind of thicket we got into about public subdivision, political subdivision, what does that cover and what doesn't, and getting a quasi-public entity took care of that problem when we got to the Pease Development Authority, and so let's hope this gets looked favorably upon by the House, but we will find out. So I'll move the amendment 0242 as.
Is there a second?
Second, but.
For discussion. All right.
All right, I had the notes that it conflicted with 370. And does the amendment really take care of that? It talks about P's. Doesn't say university.
No, it does not.
Did it need to?
No, that she apparently investigated that part of it, so.
And I think Jim, what it does is that the quasi-public entity is inclusive of USNH and CCSNH without having to name them specifically. And so that was why that was used. So
Okay.
they're not political subdivisions, but this is the way these two bills were kind of mashed together, was to do it that way.
All in favor of the amendment?
Aye.
Any opposed? Seeing none? You're out to pass on the bill?
Yeah, ought to pass as amended.
Is there a second?
Second.
All discussion? Seeing none? All in favor? Say aye.
Aye.
Any opposed? Seeing none? I guess I'll take this one out
Yeah,
too.
great job.
Do you know which
Great
one?
job, Mr. Chairman. Really, this is good. This is really a good thing.
Senator Perkins Coker's bill, did we act on that one?
Well, now we can, I guess.
Yeah.
And what is it? Was it 370? Is that what you said, Jim?
That's the one that I said that it had to conflict.
Yeah, okay, so what do you want to do? You want to,
I just want to put.
interim study, or?
Interim study, we can hold it, or.
Yeah, we might need it for some other purposes.
Right.
So I'll move, on Senate Bill 370, I'll move interim study.
I'm going to get it out of the folder before I say anything.
Absolutely.
Sometimes I write notes.
Jody, how close are we to that, do we get? Okay. Yeah, I just wanted, yeah, absolutely.
Right. I'll second.
All right, discussion. interim study for 370, SB 370. So we're on the right bill, right? All in favor, say aye.
Aye.
Any opposed? Seeing none. Senator Waters, you want to take that out?
Yeah, sure.
Okay. That's that. Still waiting for that, so look at these faces just staring, waiting to see what's going on. Sewage. We did your net metering. Did we do your net metering one? We did yours.
Senator Graves, yeah, we did that.
Yeah, why is that my folder? Bill's not exact. That's in the wrong spot.
We chopped that way down,
Yeah, yeah. we
and
did that.
then your bill 282, I believe it was you were gonna go off and look at an amendment that would affect it.
So these are not good.
We have the amendment I worked out with Bob on 263, the council. We also have the amendment on 242, or I don't know, what's the lead bill?
263?
Yeah, I mean, again, there's just, I mean, I'm happy to do whatever you want to do, but I just want to know, we do have the amendment on 263, and we do have the amendment on the lead bill, which is what? 242?
Yeah, I think I want everybody here on these.
Yeah, I think so. I do too. I mean, I just
Yeah,
wanted
so,
to
all
say
right.
that's what we had, so.
We'll get out of
It's all
exec.
good.
Yeah. Is there a motion to move out of exec? Unless you want
Move to come out of executive session.
So, seconded.
All in favor, say aye.
Aye.
Any opposed, say none. And we will close the hearing. Or session, or today, or whatever we're doing. And thank you all. We're done. Yeah, I like a full deck here on the other one. I wanted to do your one with the council and the kids, but.
Oh, by the way, they had their annual meeting, they voted unanimously in support of it. But I think Bob had some good thoughts, you know.
Yeah, it would have been good if all of us were here for that.
That's all right.
Yeah.
Well, no, I mean, there's no hurry.